diploma in alternate disputes resolution in the year 2012. She holds a certificate course in alternate to violence from Bradford University, United Kingdom. She holds a master in international peace and conflict resolution from Bradford University, United Kingdom. In the year 1995 to 1999, she rendered her services as a law professor at Law College at Nanded. Between the period 2000 to 2007, she rendered judicial service as judicial magistrate and civil judge. 2007 to 2008 as legal registrar in Maharashtra State Consumer Commission. Between 2008 to 2011, Special Metropolitan Magistrate Special Court formed under the Immoral Traffic Prevention Act at Mumbai. Between 2012 to 2013 as a judge of Special Court for Beggars. From 2013 to 2020, that is till date, she is a family court judge, and Madam has adorned as principal judge of various family courts in state of Maharashtra and also was former principal judge family court Mumbai. She has a flair for writing and her publications include writings on various sensitive topics and issues like Immoral Trafficking Act 1956, a topic of breaking the glass ceiling, child witness room, a necessity of family courts, which was published in Pratibimb, the Journal of Marriage Counseling. Madam is a recipient of several prestigious awards like Trafficking in Persons Hero Award 2011 by the US Department of State, which acknowledged her work done in respect of the issue of human trafficking. She was awarded the title of Nanded Icon 2012. She was specially appointed by the Honorable Chief Justice of Bombay High Court for monitoring and regularizing the derailed functioning of Maharashtra State Shelter Home in a suo motu writ petition number 113 of 2012. She also was a key member of the technical committee that drafted the Handbook for Judicial Officer on Anti-Human Trafficking Act 2012. She was awarded the Vocational Excellence Award by the Rotary Club of Bombay. She is a judge-trained mediator. She is also a trainer of trainee in human trafficking. She has received the Rotary Peace Fellowship Award 2013. She has also completed applied field service in 2014 for strengthening legal framework to prevent children from sexual abuse in Bangkok, Thailand, with the Office of United Nations on Drugs and Crime Regional Office. This Honorable Chief Justice specifically called for her suggestions in criminal PIL, Freedom Firm versus State of Maharashtra, and it formed the guidelines for all the judges in respect of modalities of bail in order to prevent the accused from absconding pending the trial under the Immoral Traffic Prevention Act. She has served as a chairman of the drafting committee formed by Commissioner Minister of Women and Child Development for amending the existing Bombay Prevention of Begging Act. Not only this, she has her own aura of on in the international events. She has presented paper on sexual and reproductive rights and gender violence in women and human rights summit organized by Congress at the International Federation of Women in Legal Careers, Lisbon, Portugal. She has moderated the session on ending impunity for trafficking crimes at the International Conference on Women Trafficking organized by Women and Child Department, State of Maharashtra and International Justice Mission at Mumbai in June 2017. She has paneled a conference on rehabilitation of human trafficking victims at Biennial Conference of International Women Judges Association held at London in 2012. She has witnessed the launch event of Gender-Based Violence Emergency Response and Protection Initiative held at the US State Department, Washington. Then she has paneled a global summit to end violence against women organized by Vital Voices held at Brasilia, Brazil in 2012 and Washington in 2010. She has also participated in national events like she has been a guest speaker at LBS Academy She was invited as an expert speaker in training of judges at the Chandigarh Judicial Academy. She has conducted sensitization program for judges of family court on family laws organized by High Court of Delhi in May 2018. She delivers lectures as guest speaker and has delivered lecture on stakeholders responses and challenges on violence against women. She has participated in Bharat Yatra set across the country to mobilize action against sexual abuse and trafficking of children. She has attended the consultation meeting to discuss the upcoming book on children's charter. She has served as a resource person at workshop on gender justice and women empowerment. She acts as a guest faculty as National Judicial Academy, Bhopal, Maharashtra Judicial Academy, Uttan, and National Police Academy, Hyderabad, on the topic of adjudication of cases concerning human trafficking and sexual abuse offences. Recently, in the lockdown, she has also written a book pertaining to sexual abuse with children. With such strength and experience in this field, I request Madam to guide us all on the aspirants of the topic, all the aspirants on the topic of the Criminal Procedure Code and the Family Courts Act 1984. Yes, Madam.
मॅडम आवाज येत
Madam, your voice is not being heard. Just see your mic na, madam. It must be off. Put on your mic na. शरद त्यांचा माईक अनलॉक करा.
Am I audible now?
Yeah, madam. Yeah.
Okay. So first of all, I'm very much humbled with the line-to-line introduction done by Advocate Shabnam Kazi. Thank you, Shabnam, for that. It was very much in detail, and even I was listening what I have done in past. So thank you for the detailed introduction. I'm also thankful to Advocate Valunjikar and the members of BCMG who have made me part of this very useful initiative, which is for preparing the aspiring young lawyers for the family court examination, upcoming family court examination. So I'm very much happy to be part of this initiative. Now coming directly to the topic, today's topic is CRPC and matrimonial laws. But these two subjects, which are like CRPC and matrimonial laws, we have to see that today's discussion is revolving around what all cases will be dealt by the family court and is pertaining to the syllabus which you are right now preparing for the examination. Now, as I understand, the first paper for this family court examination is of objective type. The first round of examination is of multiple choice, or what we call as you get a lot of, 3 or 4 alternatives, out of which you have to select one answer, which would be the correct. And there is also negative marking system. And for this examination, you will get around, I think, 30 to 40 seconds to answer one question. So your preparation should be focused. In such a way that you are able to answer that question correctly in maximum 35 seconds. So it is expected in multiple choice tests that you select the correct answer. The situation is you are given 4 to 5 options, out of which you have to select the correct answer. Now, when you're preparing for this type of objective examination, from my past experience or whatever examination in past I have given, you should think that your preparation is going in a correct way. If after reading the question, before seeing the alternatives, the answer blink in your head that this should be the answer, And that particular answer you should find in the 4 options or 5 options which are given in the question paper. For that, you will have to do exercise by collecting the past examination papers and solving it. That is the correct way of examination, preparation for examination. Second thing, at this point of time, I think reading judgments and the precedents is not so very useful. Yes, I cannot say it is not useful, but as far as objective test is concerned, I think it's better to read bare X word to word. Instead of reading, you have to scan the bare X. So I have this book, which I will show it to you. Divorce, Marriage and Divorce Laws. It has all the bare X in one compilation, which are very much useful. So what you have to do is you have to scan the bare X, which will help you in finding the correct answer. So coming to today's subject, Code of Criminal Procedure and Matrimonial Laws. The most used provision of CRPC in family court from the CRPC is section 125. This provision is about maintenance to the dependents. Now, first question, which may also appear in the examination, as to under which provision a petition under section 125 of CRPC can be filed in family court. Now, if you see section 125, the word used in this particular section is the court of magistrate. So primarily it is the court of JMFC or the magistrate who have jurisdiction to decide the petition which is filed under section 125. Now, how come it comes under family court now? So we have to read CRPC also with Family Court Act to understand under which provision a petition under section 125 can be filed in the family court. If you see section 7 subclause F of Family Court Act 1984, it says, as per the jurisdiction clause, a suit or proceeding for maintenance can be filed in family court as per section 7F of Family Court Act. So now this section gives the way for a petition under section 125 of CRPC to be filed in the family court. Now, what are the objectives of 125 CRPC? So before giving any examination or studying any law or any enactment or statute, the best way is to understand the objectives of that statute, as to why this statute was needed for the society and why it was enacted in the first place. If that thing is, like it is said, always said, that whenever you read constitution and you are stuck somewhere, that you don't understand any provision of the Constitution of India, go back, open the first page, read the preamble of the Constitution, and you will find all the answers where you are stuck while reading the Constitution. The same way, for understanding any legislation or statute or law, you have to see the objective of that law, which has all the answers. So whenever you are stuck, you will get the answers in the objective, and you will understand, it will help you in interpreting in the interpretation of the statute of which you are preparing. So what are the objectives of 125 CRPC? The main objective of this provision is to prevent starvation and vagrancy of the dependents. Section 125 of CRPC is a means to provide a speedy, inexpensive, and effective remedy against persons who refuse or neglect their duty to maintain persons dependent on them. The section discharges a social function in order to achieve and maintain societal balance. This is the first primary objective. First is to prevent starvation of the dependents. Now we'll see later who are the dependents and who is the provider. Then there are personal laws since long back which were available and which were sort of relevant provisions giving maintenance to the dependents. So why there was need to enact another provision for maintenance? The answer is in the objective: to provide a speedy, inexpensive, and effective remedy. This may appear as a question in your objective, that what is the purpose of 125? The answer would be for speedy, inexpensive and effective remedy, Section 125 was enacted, even though there were already legislation available under all personal laws dealing with maintenance. Another objective of Section 125 is to ameliorate the sufferings of the destitute wives, children, old and aged parents. And technicalities have no place in maintenance cases as far as Section 125 of CRPC is concerned. Now, this is the objective of Section 125. Now, let's come to the objective of Family Court Act. Establishment of Family Court Acts is with a view to promote conciliation and secure speedy settlement of disputes relating to marriage, family affairs, and for the matters connected therewith. Now, if we see Section 125 of CRPC and objective of Section 125 of CRPC and the objective of Family Court Act, we see that both these legislations speak about one's duties and obligation towards the dependents of his family members, right? Now, both these statutes are procedural law aiming for social justice. Now, let's see now how the provisions of Family Court Act are attracting the applicability of CRPC. Now, coming to Family Court Act, what is the procedure which is followed in Family Court Act? Section 10 of Family Court Act is important for that. Section 10 subclause 1 of Family Court Act says that all the cases, suits, proceedings, petitions which are filed in the Family Court Act shall be ruled by Code of Civil Procedure. Okay, so if there is a case of divorce, if there is case of maintenance under personal law, if there is a custody issue, if there is some declaration or say injunction sought, the procedure which will be followed in Family Court Act as per Section 10 is the Civil Code of Civil Procedure. Now, whether this criminal procedure comes into play in Family Court Act is described in Section 10 subclause 2 of Family Court Act. I will read the particular section. Section 10 subclause 2 of Family Court says that subject to the other provisions of this Act and the rules, the provision of the Code of Criminal Procedure 1973 or the rules made thereunder shall apply to the proceedings under Chapter 9 of that code before Family Court Act. What is Chapter 9? Chapter 9 is from Section 125 to Section 128, and it is about giving immediate effective remedy of summary remedy of maintenance to the dependents. So in Family Court, if as per Section 7F, if a petition under Section 125 CRPC is filed, the procedure which the Family Court will follow for disposing of this petition of maintenance under Section 125 is according to Section 10 subclause 2 of Family Court Act. Now, one of the very unique procedure or highlight provision of Family Court Act is also Section 10 subclause 3. Subclause 1 says all other cases except the cases falling under Chapter 9 of Family Court Act shall be dealt with as per the procedure prescribed in Civil Procedure Code. Only the cases which fall under Section 125 to 128 of CRPC will be dealt by the procedure given in Code of Criminal Procedure. Coming to Section subclause 3 of Section 10, which is, I said, the unique provision, it says that a family court shall not be prevented from laying down its own procedure with a view to arrive at a settlement in respect of the subject matter or the suit or proceeding, or at the truth of the facts alleged by one party and denied by the other party. So liberty is given to the family court under Section 10 subclause 3 to coin or lay down a procedure of its own, of course with using all the judicial discretion, to settle a matter and to solve the dispute between the parties. So this is a unique procedure, unique provision, which is I think one of the enabling provision in the hands of the family court to lay down its own procedure apart from Civil Procedure Code or the Criminal Procedure Code. there can be judicious intervention by the family court to settle a dispute by laying down its own procedure. Now, while we are talking about procedure, we also have to just touch Section 14 of Family Court Act, which is application of Indian Evidence Act 1972. A family court may receive as evidence any report, statement, document, information, or matter that may, in its opinion, assist it to deal effectually with a dispute, whether or not the same would be otherwise relevant or admissible under the Indian Evidence Act. This is also a distinguished provision in Family Court Act, allowing the family court to accept evidence which otherwise is not accepted in civil and criminal court. But this I think is a special topic in itself, which will be governed, which will be taken, I think, later in the lecture series regarding the applicability of Indian Evidence Act in Family Court. Now, coming back to Chapter 9 of Code of Criminal Procedure, I can say that it is a blend of substantive law and procedural law as far as Section 125 to 128 of CRPC is concerned. The legal requirement for someone to maintain their spouse, children, aged parents is known as maintenance under this code. In normal course, maintenance means suitable housing, clothing, food, and other basic needs. The word maintenance should not be used in such a limited sense, though. It can include all such expenses required by the dependents to lead a dignified life. It can include education expenses, though it is not mentioned in Section 125 that education expenses is a maintenance. But yes, education expenses of children and other child-centric needs and other requirements which can also be treated as a maintenance under Section 125. Now, Section 125, Order of Maintenance of Wives, Children, and Parents. It says that if a person having sufficient means neglects or refuses to maintain wife, unable to maintain herself, legitimate or illegitimate minor children, whether married or not, unable to maintain itself. C, legitimate or illegitimate child who has attained majority where such child is by reason of any physical or mental abnormality or injury unable to maintain itself. And D, father or mother unable to maintain himself or herself. A magistrate of the first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance of maintenance to his wife or such child or father or mother. Now, this is Section 125. Now, if we see Clause A, it says his wife unable to maintain herself, which means it is giving a clear indication that a man has to pay maintenance to his wife who is unable to maintain herself. Then if we come to Clause B, a man has to pay maintenance to his legitimate or illegitimate minor children. Now, if we come to Clause C, a man has to pay maintenance to his legitimate or illegitimate children who have attained majority, but due to some reason of physical or mental abnormality or injury are unable to maintain themselves. And the last, his father or mother unable to maintain himself or herself. Now, all these clauses gives an inference that a man has to pay maintenance, but there are now in the last clause it says that a magistrate of a first class, upon proof of such neglect, order such person. Now, this such person again gives an inference, if we read the first line, that a man has to pay maintenance, a son has to pay maintenance to his old and aged parents. But now the position is that there are various judgments of apex court and high courts that even daughters who are adults and who are themselves earning and has independent source of income are liable to maintain their old and aged parents. It is not only the responsibility of a son, it is equal responsibility of daughters to maintain their old and aged parents. But I would again raise a red flag here, that if a question comes in the objective objective type, then we have to go by the options given, and if there is no such option given, uh, sorry, if there is option given of daughter, and if there is option given of son, if there is an option given both, then the correct answer would be either both, or if you have to see the options, and if there is an option of daughter given, you have to pick that answer daughter as right, because the legal position now is, even though section 125 does not mention daughter, but daughters are liable to provide maintenance under section 125 to their old and aged parents. So if you read the section, if you interpret it and understand it properly, you will be able to answer that objectives correctly. Now coming to section 126 of CRPC, it is regarding the jurisdiction. Now, proceedings under section 125 may be taken against any person in any district, again, where he resides. B is where he or his wife resides, or C, where he resided with his wife, or as the case may be, with the mother of the illegitimate child. So there are three places where a petition or proceedings under section 125 can be initiated: where he resides, or where he resides with his wife, or where he lastly resided with his wife or the child of his illegitimate. Now, what happens if a petition under section 125 has to be filed by a mother, old and aged mother, or old and aged sick father? Where would that father be able to file petition under section 125? Now, I have prepared one short 10 question and answer round in the last session. So I will deal with this issue in the last portion. Now we'll move ahead. We'll see what is section 127 of CRPC. It allows alteration in the quantum of maintenance allowed under section 125 if the applicant proves that there is change in circumstances which warrants alteration in the maintenance. For example, a wife is allowed maintenance under section 125 of CRPC, and subsequently there is divorce between the husband and wife. Not only that, but the wife proceeds and moves ahead in the life and gets married to another person. But the order under section 125 of CRPC is still in existence. In such circumstances, the husband can apply to the court under section 127 and seeks cancellation of maintenance in the changed circumstances. He can say that when the maintenance was passed, she was my legally wedded wife, but now she is legally wedded wife of some other person, and there is divorce. So these are the change in circumstances, which which becomes a ground to cancel the maintenance allowed under section 125. Now, section 128 of CRPC is also a section in the maintenance provisions to the wife, children, and parents, which oversees the enforcement of the order of maintenance passed under section 125 of CRPC. This section says that a copy of the order is provided free of cost to the other party in whose favor it is granted. So 128 is the enforcement of the order of maintenance. It has no bar, it has no limitation of time. It also says that it can be filed anywhere by the applicant for recovery of the maintenance. Now, we will also have to see the difference between section 125 subclause 3 and section 128 of CRPC. Section 125 subclause 3 also speaks about enforcement of the order of maintenance. This I will again deal in the last portion of my session. Now after this, we come to family court now. How execution of family court's order can be done. If an family court has passed an order of maintenance under section 125 of CRPC, say family court has allowed the petition and has ordered the husband to pay maintenance to his wife under section 125 of CRPC. Execution of decrees and orders in the cases filed in family court is described in section 18 of Family Courts Act. It says that a decree or an order other than order under Chapter 9 of Code of Criminal Procedure passed by the family court shall have the same force and effect as a decree or order of a civil court and shall be executed in the same manner as prescribed by the Code of Civil Procedure 1908 for execution of decrees and orders. Which means that if a divorce, maintenance under personal law or custody matters or any other declaration, injunction, the execution of such type of orders can be done by the family court under section 18 subclause 1 by using the provisions of CPC. Now, 18 subclause 2 says that if a family court has disposed of a petition of maintenance filed under section 125 of CRPC, then it says that an order passed by the family court under Chapter 9 of the Code of Criminal Procedure shall be executed in the manner prescribed for execution of such order by that court. So all the execution proceedings will in a 125 petition will happen as per the CRPC provisions. Now, subclause 3 of section 18 says that a decree or order may be executed either by the family court which passed it or by other family court or ordinary civil court to which it is sent for execution. Now, as I said, there are two provisions, section 125(3) of CRPC and section 128 of CRPC. Both these sections speak of executing an order of maintenance passed under section 125. Now, what is section 125(3) of Code of Criminal Procedure? It says that if a person so ordered fails without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issue a warrant of levying the amount due in the manner provided for levying fines and may sentence such person for the whole or any part of each month's allowance remaining unpaid after the execution of warrant to imprisonment for a term which may extend to 1 month or until payment if sooner made, provided that no warrant shall be issued for the recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it became due. So 125 subclause 3 has a limitation clause of 1 year. Now, if you see the citations, yes, there is interpretation, and if already a petition for recovery is pending and the other petition is beyond limitation, that can also be considered. That apart, if we read section 125(3), it gives an inference that there is a limitation of 1 year. Within 1 year, that recovery has to be filed. If you see section 128, there is no such limitation. If you see section 128, there is no provision of sending the person for imprisonment. Whereas in section 125(3), the order of recovering maintenance can be executed by taking recourse of sending that person to imprisonment for one breach of order for 1 month. So both 125 subclause 3 as well as 128 both speak for enforcement of maintenance order, but has different provisions, and as per need, the party can take recourse of these provisions. Now, coming to the provision where mother and father are allowed maintenance under section 125, there is also one provision, there is also one statute, Maintenance and Welfare of Parents and Senior Citizen Act 2007. Irrespective of what reliefs are given by competent authority to parents and senior citizens under this act, the door for the parents is open always to seek maintenance under section 125 subclause D of Criminal Procedure Code. The provisions pertaining to a parent's maintenance who may not be able to support themselves is 125 subclause D. Nowhere specifically did the stepfather or stepmother fall under the definition of this father and mother, as it appears in section 125 of the Criminal Procedure Code. When the term mother is used in a general sense, it refers to a woman who gave birth to the individual whose support is being requested under section 125 of CRPC. Now, if we see the factual position, even the stepmother, there are precedents, there are citations where we find that even the stepmother is allowed maintenance under section 125 in some given circumstances. So if a question appear in the exam that who is allowed maintenance, and if there is, if you have to select only one answer and there is mother and stepmother, after you become judge, you may use your discretion and based on the circumstances grant maintenance to stepmother. But while answering in the family code examination, if these two answers are there, you have to take mother, because the legislation and the act says that mother and father, so stepmother and stepfather are out of the scope of 125 maintenance as far as examination is concerned. I would stress on that. So when we are answering objective type question paper, you have to be very, very specific and very appropriate and correct while selecting the options. For that, in the beginning only, I said you have to scan the bare acts, you have to read the bare acts, and you have to see the specific words used in the bare act, which will help you to find correct answer. Sometimes while answering, all the four options appears to be correct. I'll come to it later. So when all the four options are correct, what is expected from you is you correct or you select the answer which is used by the legislation in the statute. So stepmother, even if you as a judge give maintenance to stepmother, while answering, the correct answer would be mother and not the stepmother. Now coming to the portion of matrimonial laws. Now there is no single law for marriage. Rather, we have different laws for different religion. So in family code, if suppose a matrimonial petition for divorce is filed by a Hindu, it will be filed under Hindu Marriage Act 1955. For Muslim, under the Personal Law of Muslim. For Christian, it is Indian Divorce Act, Indian Christian Marriage Act. For Parsi, it is the Parsi Marriage and Divorce Act 1936. Those who do not profess any religion and they have preferred marrying under Special Marriage Act, all other their litigation will fall under Special Marriage Act. So there are also offences relating to marriage. Offences pertaining to marriage are provided in Indian Penal Code from section 493 to 498A, 498 and 498A. These laws deals with various aspects of a marriage and their subsequent felonies. The most illuminated of this is section 498A, which now and then appears before the family courts also when there is settlement. Those who are seeking divorce, or those who have come for custody, or those who have come for maintenance or for any other relief, they settle this 498A before the family court, but then they have to take recourse of quashing the FIR, or the main settlement happens in family court. Based on the settlement, these other pending criminal matrimonial laws cases are settled outside by taking proper recourse. Section 493 of IPC speaks about cohabitation after deceitfully inducing a belief of marriage. If suppose a woman is deceitfully induced to believe that she has married this person and she cohabits with that person, believing him to be her husband when in fact he's not, section 493 of IPC can be invoked. Section 494 of IPC is marrying during lifetime of husband or wife, or that is bigamy as we call. Then section 495, concealing the previous marriage before subsequently getting married. Then section 496 is fraudulent conduction of wedding ceremony without a lawful genuine marriage. Then 497, adultery. It is, see, adultery is decriminalized now, but it has direct relevance in the family court matters, wherein it says that it is important to note that this law has since been decriminalized, but continues to be strong ground for divorce. So if there is an offense of adultery, though under IPC it may not be criminalized, but it becomes a ground for divorce under section 13(1) of Hindu Marriage Act. Then section 498A, enticing a married woman for illicit sexual relation. Now, 498A of Indian Penal Code has the laudable object of punishing cruelty at the hands of husband or his relatives. Now, there is also section 304B of Indian Penal Code, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage. And it is shown that soon before her death, she was subjected to cruelty or harassment by her husband or any relative of her husband or in connection with any demand for dowry. Such death shall be called as dowry death, and such husband or relative shall be deemed to have caused her death. All these sections of Indian Penal Code are pertaining to marriage laws, pertaining to an offense which has happened between husband and a wife, but these these provisions does not fall under section 7 of Family Court Act, and therefore though it is I would say an offense between husband and wife, it will not be dealt by the family courts. It will have to go to regular criminal court. So these are the marriage offenses, but family court may not, family court shall not deal with these offenses, does not have jurisdiction to deal with these issues. So coming back to now, family court examination and the subject which we are talking today, CRPC and marriage laws. What I have done, I have prepared sample questions, 10 sample questions. What I will do is, I will read the question, and those who are attending here, and I will also give the options A, B, C, D, or 1, 2, 3, 4. And then in your mind, you decide which is the, I will also tell the answer, but you also see how much preparation how much ready you are to answer these type of questions, or the pattern with which you will be facing very soon when you appear for the exam. So now coming to this exercise, I think, Shabnam, how much time is left? Okay. Now, the question number 1. According to section 120,
मॅडम तुमचा नेटवर्कचा इश्यू झालाय.
Hello. 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 There seems to be some disconnect from madam's end. Just hold on for a moment.
मॅडमचं डिस्कनेक्ट झालंय, जरा थोडं थांबा. हा
मी करते मॅडमला कॉल करते.
हा, फोन करा.
हा.
Okay, so I'll read the question again. According to section 125 of CRPC, who is a minor? The options available are who is below 18 years of age. Second option is who is a child. The third option is means a person who under Indian Majority Act is deemed not to have attained majority. And the fourth option is any person, male or female, who is not an adult. If these four options are given, which is the correct answer? For finding out the correct answer, you must know what terminology is used in section 125 of CRPC. So the correct answer is clause number 3. According to section 125 of CRPC, minor means a person who under Indian Majority Act is deemed not to have attained majority. Though all the answers practically are correct. A minor is a person who is below 18 years of age is not wrong, is correct. Minor is a person who is a child is also correct. Minor is any person, male or female, who is not an adult is also correct answer, prima facie. But which is the perfect answer which is expected is minor means a person who under Indian Majority Act is not deemed to have attained majority. Then your answer is correct. Exactly as per the words which are used in that section. So that is why I'm telling you that scan the where act. You should know what terminology is used in the statute to find out the correct answer. Now, another question is under section 125 of CRPC, who is a wife? The four answers given to you is who has been divorced. Another is who has obtained divorce. The third is who is the first wife. And the fourth is all the above. Now, under section 125, who is a wife? Normally we said legally wedded wife, but there is an explanation given in that clause that who is a wife. So in this given case, all the above are correct. Wife is a person who has been divorced. Wife is a person who has obtained divorce and who is a legally wedded wife. If any woman falls in this three category, can claim maintenance. So in this case, the answer would be all the above. Now, if there is a question, if the order of maintenance is not complied, for every breach of every such order, the court may sentence such person for the whole or portion of each month's allowance to imprisonment for a term which may extend to 1 month or until payment sooner made. The answers are under section 128 of CRPC, under section 125 subclause 3 of CRPC, above both sections, and the fourth option is section 421 of CRPC. Now, at a glance, all the answers are not wrong. All the answers are not wrong. But what the question is very specific, that if you want to send a person to jail for the breach of the order of maintenance, then which is the correct answer? 125 subclause 3 of CRPC is the answer. Though under section 128 recovery of maintenance is there, Under 421 of CRPC, yes, recovery is prescribed. So all the above are prima facie not wrong answers, but which is the correct answer? 125.3 is the specific answer. So if you read 125 to 128, scan it, you will know that there are two provisions for recovery of maintenance, 125 sub clause 3 as well as 128. And in the given question, 125.3 is the correct answer. Now, another question is, no wife is entitled for maintenance under section 125 of CRPC if she is behaving in a cruel manner with the husband. Second option is living in adultery. The third question is living abroad. And the fourth is all the above. Which is the correct answer? The answer is living in adultery. Sometimes, you know, there is a situation where maintenance, where there are citations, or it is a common understanding that if a wife is behaving cruelly with the husband, she's not entitled for maintenance. That is not the case. The act, you have to go what the words in section 125 are used. So it says that the wife who is living in adultery is not entitled for maintenance under section 125. If she's living abroad or even if she's behaving cruelly, the correct answer is she should be living in adultery. Therefore, she is not entitled for maintenance. We'll move to next question. The magistrate can cancel the maintenance on proof that the wife is living in adultery, refuses to live with husband without any reason, or they are living separately by mutual consent. Which is the correct answer? Options are under section 127 of CRPC, under section 125 subclause 5 of CRPC, under section 128 of CRPC, or clause 1 and 2. Again, see, 125 subclause 5 and 127 give similar inferences. Section 127 also is cancellation, change, alter the maintenance quantum, whereas under section 125 subclause 5 also speaks about cancellation of maintenance. Now, in this case, what is the specific question? When can a court cancel the maintenance on proof that wife is living in adultery or refuses to live with husband, or they have mutually separated? Then 127 is not the answer. The answer is under section 125 subclause 5 of CRPC. Because 127, I gave you the example when I was speaking about 127. It is alteration in maintenance, in changed circumstances. Here, the wife is living in adultery, or they have mutually decided that, okay, we are living separately now and we don't want to go ahead with this maintenance. Then in that case, 125 subclause 5, the court can cancel the maintenance. Otherwise, 127 would have been the answer. Now we'll move to other question. Proceedings under section 125 of CRPC by old and aged and sick father can be taken against his young and able-bodied son at the place. The options are where the father resides, where the son resides, where the son got married, or where the son was born. Now, while speaking about section 126, I had kept reserved this issue that suppose a wife wants to file petition for maintenance, she has the privilege to file petition where she is residing or where she and her husband last resided together. As far as old and aged parents are concerned, there is no such privilege. We have to go A, B, C of 126, which means where the son is residing. Now, in this question, the question is old, aged, and sick father. Where can the father file? Where the father resides, normally we feel that, okay, it is justified that where the old and aged father is residing, he should be able to file that petition there. But your answer would be wrong if you pick that where the father resides. The answer is where the son resides. There's no, the situation yet in section 126 of CRPC is whatever is given in A, B, C, where he resides, where he resides, where the wife resides, or where they both last resided. So there's no specific provisions for parents. So parents will have to file petition for 125 CRPC where the son resides. Unfortunately, if son is not residing in the same city, he is residing somewhere else, the parents are under obligation to file the petition where the son is residing. That would be the correct answer. Then under section 126 subclause 2, the magistrate may set aside the ex parte order so made on an application made showing good cause. The options are within 90 days, within 60 days, within 3 months, and within 30 days. Now, if you read section 126, now there are two answers which are very similar. The answer is, the option is 90 days, 60 days, 3 months, 30 days. So 3 months and 90 days practically are not different. Both are the same. Inference is the same. But then why this 90 days and 3 months is given? Now here, if you scan while you study, if you scan the provisions, you will read that under section 126(2), the word used is 3 months. So 90 days is no different. But if you take 90 days, your answer would be wrong. What is the correct answer? 3 months. So under section 126(2), a magistrate may set aside the ex parte order so made on an application made showing good cause within 3 months, not 90 days. Now, another question. An order passed by family court under chapter 9 of Code of Criminal Procedure shall be executed under order 21 of Code of Civil Procedure, under section 10 of Family Courts Act 1984, in the manner prescribed for the execution of such order by the Code of Criminal Procedure, all of the above. Now, we have a very strong impression in our heads that 125 is a quasi-civil proceedings. All the provisions of CPC can also be applied. Okay, in practice, yes, there are citations. The position is that 125 is a quasi-civil proceedings. But when you're answering in a test, what would be the answer in this? How order passed by the family court, any order passed by the family court under chapter 9 shall be executed. In my deliberation earlier, I had made this very clear that you have to be very specific in answers, and I explained section 18 and 10 both, which is in context with use of CRPC. So in this, the answer would not be order 21 of CPC, nor section 10 of CPC, nor all of the above. The correct answer would be in the manner prescribed for execution of such order by the Code of Criminal Procedure. So this is where you have to prepare. For that, you will have to sort of by heart all the provisions and understand and remember what terminology is used in the sections for answering the objective type test. Now, our last question is, a widow approaches a family court with a request to issue search warrant under section 93 of CRPC against her in-laws, alleging that they have clandestinely taken away her 7-year-old son and has kept him in wrongful restraint. There are two options. There are three options. First is family court can issue search warrant. Another is family court cannot issue search warrant. And the third is both answers are incorrect. Which is the correct option in this? A widow approaches a family court with a request to issue search warrant under section 93 of CRPC against her in-laws, alleging that they have clandestinely taken away her 7-year-old son and has kept him in wrongful constraint. The answer is the family court cannot issue search warrant under section 93 of CRPC. So the scope of CRPC in family court is to the extent that provisions of maintenance, summary relief under section 125 and its execution as per section 125 to 128 of CRPC, read with section 421 of CRPC, can be used by the family court. Other matrimonial offences, though pertain to offence between husband and wife arising out of matrimonial relationship, but will not be able to be filed in family court as per the jurisdiction clause of section 7 of Family Court Act, and has a limited scope. So this is what I have prepared today. And I think there are no question answers round. So I think this is what I have prepared for today's lecture. So thank you for patiently listening me. Thank you so much.
हॅलो शरद सर सोनालीला अनम्यूट करा ना शी इज गोइंग टू गिव्ह द वोट ऑफ थँक्स हॅलो
Yes, madam. Am I audible?
येस
It's my privilege to propose a vote of thanks for today's elegant lecture. Firstly, I would like to thankful to our today's resource person, Honorable Former Justice Swati Chauhan, madam, who has shared their valuable insights and expertise and interactive session. I would like to thanks to the coordinator, Dr. Uday Varunjikar sir, for organizing such lecture series. I would like to thank to the chairman and vice chairman of the Bar Council of Maharashtra and Goa and all the members of Bar Council of Maharashtra and Goa for conducting such inspiring activities for our young lawyer generation. At last, I would like to say thanks to all the participants, and I also wish to all the best for all the participants for upcoming exam.
Thank you, madam. Only a correction I would make. Madam is still a judge family court.
I am obliged.
Thank you, madam, once again. And to all the participants, tomorrow we will be having a lecture on the Family Courts Act by former Judge Anagha Joshi, madam. And I would request all the participants not to chat during the lecture. They can put their questions later on because we do have a session of 5 minutes after the lecture wherein they can put their questions. Thank you all. And I call the session off for today.